Good day everyone, especially to Ma'am Mercy Ratonel. By the way, I am Maricel Kaubanan Milaor and I'm going to discuss the nature of provision in the topic, the provision law of the Philippines in page 28 and 29. So let's start. First, we have the nature of provision. So effect of the grant of provision. So what are the effect of the grantees of provision? So first, in number one, we have provision is but a merely privilege. As such, it grant or denial rests solely upon the sound discretion of the trial court. After its grant, it becomes a statutory right, and it shall only be cancelled or revoked for cause and after due notice of hearing. So a provision is a privilege, and it is granted by the solely upon the sound of discretion. Uh, Provision is given by the trial court. So that is the number one. Next, we have the grant of provision has the effect of suspending the execution of the sentence. The trial court shall order the release of the provisioner, cash or property bond upon which he was allowed temporary liberty. If the person is granted by the provisions, it affect that the execution or the sentence they serve is suspend, and it has have and money to be allowed to have a temporary liberty. So if you are granted a provision, you have to pay um, the amount to be allowed in temporary liberty. So next, case analysis. Example of this nature of provision. So case analysis. Pedro was convicted of a crime and sentenced to a prison term more than 6 years, beyond the provisionable limit of 6 years. He appealed in his case, and the appellate court modified his sentence below 6 years. Question: May Pedro apply for probation? The answer is yes, by virtue of specific provisions of RA 10707. When a judgment of conviction imposing a non-provisionable penalty is appealed or reviewed, and such judgment is modified through the impositions of provisionable penalty, the defendant shall be allowed to apply for probation based on the modified decision shall be filed in the court, where the judgments of conviction imposing non-provisionable penalty was rendered, or in the trial court where such case has since been re-raffled. Also, Pedro may apply the provisions because he is not disqualified in applying in provision. The person who cannot allowed to file or to apply provision is the case they commit are um, against in our public safety. That is the disqualifications of a person. This He cannot apply for provisions if that crime he committed. So next we have the when provision order becomes effective. So it shall take effect upon its issuance, at which time the court shall inform the offender of these consequences thereat, and explain that his failure to comply with any of the conditions prescribed in the said order, or his commissions of another offense under which he was placed on provisions. So, if provisions become effective if it is issued by the court and not, no other one, who issued it. It will be become effective if the offender consequences explain his failure, and the committing crime is not really really bad, and it and the court shall issue that provision. So that is provision order become effective. So next we have the persons disqualified to be placed on probation based on RA 1070. In Section 9, disqualified offenders, the benefits of this decree shall not be extended to those. First, we have the sentence is serve a minimum term of imprisonment of more than 6 years. So if you are, so if the, if the offender serve the imprisonment or the maximum imprisonment term of more than 6 years, he or she cannot be placed on probation. He or she can be disqualified because of that. So next, convicted of any crimes against national security. So if you commit like rebellion, or like you 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 against the national security, you are disqualified and you cannot be placed on the probation. So next, you have previously been convicted by judgment of an offense punished by imprisonment of more than 6 months and 1 day, and or fine or more than 1,000 pesos. Next we have the if the convicted person final judgment of offense punished by imprisonment of more than 6 months and 1 day, or you will be fined in 1,000 pesos, you are disqualified because that that sentence you serve are longer not longer like 6 years or 5 years, 1 years. That is the disqualifications of to be placed on probation. So next, who are already serving sentence at the time the substantive provisions of his degree become applicable pursuant to section 33 thereof. So the persons if the persons who are offender are already serving the sentence, are he or she is disqualified to be placed on probation. So next, so that's all for my discussions. It talks about the how how effective the provisions is, and thank you for the your thank you for listening.